When it is your turn, the meeting moderator will unmute your microphone and acknowledge you to proceed with your comments. If you're participating over the phone, you must press *6 to unmute. Also, please email any documents that you need to use in your presentation to planning@dmgov.org if you have not already provided these to city staff prior to the hearing. Once all concerned citizens have spoken, the board will then ask any additional questions of city staff. Lastly, the applicant will be given 3 more minutes for rebuttal or other closing comments. All speakers are required to begin their presentation by giving both their name and address of business or residence. In the event you may need to be contacted for legal notices related to the outcome of this appeal. All speakers are requested to remain courteous and to focus their comments only upon those facts that demonstrate whether or not the criteria established by law have been satisfied. Speakers are also asked to ensure that they are respectful of time considerations. If necessary, the board chair, or in this case, the board vice chair, will limit further comments by a speaker if they exceed their time limitation. The board will then close any further public comment on the agenda item, and the board will immediately deliberate the request and make a decision on the appeal. Please note that it takes at least 4 affirmative votes for any zoning appeal to gain approval. That's regardless of the number of participants that we have on the board in attendance. If your appeal is approved today, we ask that you wait until at least 1 week from today's hearing to contact the city's Permit and Development Center to obtain any necessary building or sign permits related to your appeal so that the decision of this board can be documented in the form of a decision and order, which will be provided to you and city staff. Any appeal that is approved by the board must be implemented, constructed, or otherwise utilized within 2 years of the date of the decision by this board, or such approval shall expire. The decisions of this board can only be appealed to the Iowa District Court. If you believe you have been harmed by an error made by this board, your only remedy is to seek relief through the court within 30 days of the filing of the board's decision and order. If you believe the zoning regulations applied by this board are wrong, you may petition the city council to change those regulations for future considerations. All material written or otherwise used today as part of any presentation is part of the permanent record. You may contact city staff after the hearing if you need a copy. Finally, we ask that you keep your microphone on mute other than when addressing the board to limit distractions during the hearing that is in progress. We also ask that you refrain from using any chat or question and answer function as part of this Zoom meeting, as that conferencing function will not be monitored for response. And use of that function could be construed as ex parte communication outside of the hearing process, which is prohibited for our consideration. With that, I'm actually going to go back to not being seen, but wanted to welcome everyone here this afternoon before we get into the meeting with my semi-smiling face. So thanks everybody for your time. And Bert, I guess we can get going on the agenda.
Sure. Yeah, thank you, Nathan. This is Bert Drost, planner for the city of Des Moines. Today's agenda includes 6 items. Number 1 is our only consent item, and that is a request from the Graziano's grocery store for a conditional use that would allow them to sell wine. So staff has recommended approval of this conditional use, and we're recommending that it stay on the consent portion of the agenda today, unless there's anybody in the audience who wishes to hear it. And there are no other changes to the agenda. We'll hear the other 5 items one by one.
Okay. So as Bert stated, this is the consent portion of the hearing. Usually we have more than one, so we're handling more at once, but this time we just have 1 item. But the difference from all the other items will be we're not going to actually hear this unless there is someone in the audience that is opposed to the staff recommendation that's been kind of submitted already for this conditional use permit. So I'll give a minute in case anybody wishes to speak. Either raise your hand or push *9. Whether you're in support, well, no, if you support it, you don't need to do that. If you oppose it. I don't see any, Tyler. Is that right?
Yep.
Yeah,
I'm not seeing any.
All right. So with that, we will move to, I guess, if anybody on the board wishes to move make a motion for the consent items.
I make a motion to approve the consent item 1.
Great.
This is Marlis. I'll second.
All right. Motion by Justin, second by Marlis. Any discussion? Hearing none, let's go to the vote.
All right, Cindy Smith,
Aye.
Marlis Jones,
Aye.
Justin Gross,
Aye.
Dave Gare,
Aye.
Lynn Carlson,
Aye.
and Nathan Blake.
Aye.
Motion carries 6-0.
All right, unanimous. Thanks very much. If you were here for that first item, you can, well, feel free to stick around, but you don't need to. That information, as I indicated at the beginning, will be available to come in when you come in next week. All right, moving on to item number 2. And I think Eric is the one I'm supposed to turn to now.
Yes, Mr. Chair, item 2 is at 4701 Fleur Drive. It's a request from the property owner, Raccoon Valley Investment Company, on behalf of the business involved here, which is Hy-Vee. We're talking about one of the gas station location, and I'll show you the map here in a second, but it's to allow installation of 2 wall-mounted signs. And the dimensions are given there, 40.63 square feet and 89.36 square feet on each of the north and south facades of the building respectively, which end up with a combined square footage of 129.99. That triggers 2 things here. That triggers a variance of what's allowed total for the building, which is a maximum of 42.5 square feet based on the north or the west wall that fronts Fleur Drive. And then also it's over quite a bit over on what was earned for a maximum amount on a non-frontage wall. They're looking for both signs to be on non-frontage walls. So the total square footage that they're proposing is over the 21.25 square feet allowed to be divided amongst those 2 walls. One thing you need to understand here is that the difference between the 129.9 and the 108.74 proposed involves existing pricing signs. So this is the overall parcel, which also includes the Hy-Vee commercial center with the main store. The area in question is down here in the lower left-hand corner of the property. There's actually a portion of right at the intersection that's not part of the site, and also prevents this site from getting frontage the way it's looked at for earnings. This is looking at from internally to the south at the north facade on the existing proposed. Now they are proposing to take these canopy signs off, I believe. This is working your way around it. And again, they have a lot of landscaping that's already established here. This is the west side of the canopy and that same north side of the building front. That's backing out a little ways to give you another perspective. This is looking at the south facade at the existing sign that would be replaced. . So now kind of an overall aerial view of what they're proposing. The monument sign here isn't really under consideration by the board today. They shouldn't have any concerns with refacing that sign. They're focused on basically removing the existing channel letter signs on the building on the north and south facades, and then putting up their new branding. This would be the north side, and then this would be on the south side. So you can see they've done a render or photo to show what's there now and what's after. This is their monument sign. They would just reface that top portion for their new branding. And then this shows that they would remove their canopy signs. This is the staff report that was sent to the board and the appellant. I'm going to focus here on the staff's rationale here. One of the things I would point out is that the situation or the scenario we're dealing with here creates a situation where the signs that they are wanting are both considered signs that are on non-occupant walls, and they're having to take the earning that they would earn based on the west wall of the building along Fleur and apply that to the front and back of the building, which are non-occupant walls on the north and south. We certainly think there's some practical difficulty given that scenario and the positioning of the existing building and the amount of frontage and the fact that there's separate ownership of the property to the south that would give additional frontage earning onto McKinley. But we aren't seeing a variance scenario where they would be deprived of all other economic use of the site. We would support approval of a exception level. We do believe there's the practical difficulty situation here. And then we've written that up here that shows a different amount of signs where that sign area that would be earned could be increased by another 50% additional over that 42.5 earned. And then when that gets divided across the two north and south non-occupant frontages, we realize there's 50% of that earning that would be not used. Therefore, staff would also support allowing a third sign to be earned, one over the two that they would earn, and allow them to use that other 50% of the area on the west frontage wall, which would be along Fleur. We do believe that this meets the criteria of granting the exception. Again, staff is recommending denial of the variance requests, but a revised appeal to allow exception level area based on the earning of 50% over what would be earned, allowing a total of 63.75 square feet. And that would basically be split between the north and south non-occupant walls of the building. And then we had also recommended a third another exception be added that would allow a third sign. And that would allow that additional 50% of the 63.75 square feet to be placed on the west Fleur Drive facade. This would be subject to having any signs installed be in compliance with the permit, and that the condition that they be held to the removal of the logo signs on the fueling canopy that they've indicated. These are the consent cards that were sent out. Everything received back was in favor. We got one from the Southwestern Hills Neighborhood Association. And then we also had a email communication from Mitch Harris with Watrous South Neighborhood in favor. This is the consent map showing the cards that we received. I don't have anything further unless there are questions from the board.
I've got a couple quick ones just so I understand exactly what's being requested. One is they're not asking for any sort of a variance over the number of allotted signs. Their two requests are for the total square footage of signage, and then the second one is for one of the signs that it be bigger than what's allowed.
Right. Well, it's actually for the total area that would be allowed on non-occupant walls.
Okay.
So it's both appeals involve the two proposed signs. And then staff is recommending exception level appeals. When you give the exception level appeal on the total amount, they're only able to apply half of that amount to the north and south walls. So there's this unused portion that's earned that they're not even proposing to use. So staff is also recommending a third appeal be considered to allow an additional sign so that they could use the additional, 31 plus square feet of earning on that west wall, which would give them that visibility and still be within an exception level.
And on that third point, I assume that the board has in its discretion to grant that type of exception, even though the kind of commensurate variance was not requested.
Right. So it's a lesser level of appeal than was originally noticed and requested. So,
okay.
But because of the way we're amending the recommendation from what is requested, it drops the amount of signage, earned quite a bit, and we wanted to also put that in as an opportunity for them to take advantage of half of the sign area that they earn and apply it to that primary frontage wall on Fleur.
Nathan, this is Judy Parks Cruz, and you may not recall from past meetings, but we have, in situations where a variance has been the request, denied the variance, but then granted a type 2 exception instead of that, rather than making them come back with that separate request.
Yeah, no, I understand the step down concept. I guess what I was, and I assumed this was the case, I just don't remember any instances where we've done this, where they're not asking for, say, a variance to go from 2 signs to 4 signs, and then we're going to grant 3 signs, right? And that was never noticed, the number of signs. All they've requested is area, and what staff is recommending is granting those exception level area requests, denying the variances, but then adding this third one, which again, not to tip my hand, I mean, I understand that the concept behind it. I just wanted to just doubly verify that that was okay, even though the concept of like adding the number of signs had not been noticed.
Yes, we can do that.
right.
Yeah, and it's also a way of essentially capturing what they would earn.
Yeah.
It is another 50% additional to what they would earn on that wall, but
Other folks
I'm
on the
not
board
sure.
have, okay. Thank you, Eric and Judy. Do other folks on the board have any questions for staff at this point? Hearing none, let's turn it to the applicant or representative of the applicant.
And I think Bree is here on the call from Hy-Vee.
Bree, if I think I did see your hand raised earlier. I don't know if it still is or not. Despite
She has her hand raised. She just needs to unmute so she can speak.
Okay. Bree, you should be allowed to unmute at this point.
Yes.
Okay,
Can
great.
you hear me now? Very good.
Yep. If you could just
can't
state your name and address, and then you'll have up to 10 minutes to present.
Very good. My name is Bree Cooper. I'm Director of Retail Facilities at Hy-Vee. The address is 5820 West Town Parkway, West Des Moines, Iowa, 50265. And I am representing the program that we're putting out where we're rebranding. We have reviewed the staff recommendation and reevaluated the sign areas that we had requested. And so we are accepting the staff's revision of the variance request that we've put in. However, for this particular location, we'd want to maintain the signs, only 2 signs, north and south face of that, rather than have the west facing sign on Fleur. So it is slightly different than has been discussed through there. And I don't, the technicalities of whether or not the board can make that kind of an adjustment based on the staff recommendation is what we're kind of asking for at this point. We see that there's a lot more value with the north and south facing visibility rather than the Fleur visibility, just because of the way the building is oriented. So we'd like to have that sign area. Again, as Nathan stated, we're really asking for the sign area in variance to be on the north and south facing walls. So it is not as large of a variance request as was initially submitted, because we have recalculated it to be within the size. And I had sent over to Bert the revised building elevations that show those smaller signs than what was originally submitted. So they have been scaled down to fit closer to the staff recommendation.
Bert, do you want me to stop sharing so you can?
Yeah, well, they were emailed to planning as well, so you should have them, Eric.
Okay, I'll put them back up as soon as I get into my email and open them.
And I should note too that Ed Peschke from Nesper Signs should be on here as well. So if we have specific questions about the calculations that were run and the modifications to the sign after we received the hearing notice and recommendations, he can speak directly to that.
Thanks very much, Bree. While Eric is kind of pulling up those drawings, let me just make sure I understand what you've said here. It sounds like you're close to comfortable with the staff recommendations, or you are comfortable with the staff recommendations?
We are comfortable with the staff recommendations as they fit the size of the signs, because we've redone the calculations and scaled the signs to fit within those numbers. But
Yep.
what we want is to use those values for a north and south facing sign and not have the third sign. So we're not interested in increasing the number of signs, but we do want to use the area for the north and south, just 2 signs.
Okay. And-
Right, so it's still gonna require, this is Eric, it's still gonna require the variance, a reduced variance over the, for the total on non-occupant that can be placed on non-occupant walls. So she's asking to take the total earning at a type 2 exception level and dividing that amongst the 2 north and south walls. And then, but what that still will require is a variance on the total area on non-occupant walls.
Right. So our total sign area is 63 square feet. And so we're
Right.
looking at 31 square feet on north side and 31 square feet on the south side.
So they're still wanting to double the amount they would get under an exception on non-occupant frontage to the total that is an exception of the earned area for the whole site for the building. Which is that was the point staff was trying to make, is by giving them the exception of the total earned, you're only able to take advantage of half of that on non-occupant walls. And so
The
if that
other,
makes any sense to the board.
So just because I understand, and my fellow board members can jump in if there are other questions, but it's essentially then what it sounds like, Bree, is you're fine with the recommendation for an exception level adjustment to your first zoning variance request, but the second one, you're still interested in asking for a variance, although maybe with slightly different numbers.
Yes, I would say that. I think the for this location, we understand that the sign needs to be smaller. So based on our original one, and we're pulling up the Southeast 14th image here on the screen. Probably need to switch it to the next tab.
You want me to go to the number 2?
Nope, I want you to go to Fluor. There you go. So on this one, this is the ones that we just sent in. So it's 31.73 square feet, which is less square footage than what we've had on the existing Hy-Vee gas sign that's there now. And so based on the staff recommendations, we understand that the sign ordinances have changed, and we have done recalculations on the sign area that's being proposed today to be more in line with what the staff recommendations are for the non-frontage road. However, we don't need the sign, and there is no sign on Fluor today. So we'd like to use the sign area that's allowed on the 2 non-frontage sides, which is where our existing signs are located. So, you know, if we're looking at this kind of globally, we're not asking for any more sign area that's on the building now than is there today. We've actually provided less, and we don't want to add any additional signs. We just want to change the 2 signs that are on the building now. We're trying to fit them within allowable sign area that's been calculated. Whether that's on the frontage road or the non-frontage side, we're trying to fit that in there. Now, on these other 2 locations, we've recalculated and can agree to the sign recommendation. So I know we're not talking; those are agenda items 3 and 4.
Okay.
We can get
So I opened up everything for all the items. So we're just looking at this one.
Yeah, we're just talking about this one today. So we don't have any other. This is really the one where it's just a little bit different, and it doesn't fit any of the standard ordinance outlines very well. So we're trying to ask for an exception based on what's existing, and that's really the basis of how we'd like this to be looked at.
All right, thanks very much, Bree. Are there other questions from board members for Bree before she steps down? Hearing none, we'll close this portion. And did you have one more thing to say?
No, just thank you for hearing me out. Thank you
Of
very much.
course. All right, we'll close this portion and we'll turn to the public comment portion. We'll begin with any speakers who are here to speak in support of this request. If you are here to speak in support, looks like we have at least one. You'll be given 5 minutes and you'll start off by stating your name and address. All right.
Are you ready?
Ready.
All right. Hi, my name is Phil Garland. It's Philgarland. I'm president of Nesper Sign at 4620 J Street, Southwest Cedar Rapids, Iowa. And just a quick thought that I wanted to speak to the board to say, number one, to thank you for the hearing and for your time. It's something that our company doesn't do very often out in your area. We try to work within the code. We work with Hy-Vee, have for 30 some years. And I think we've only been maybe a couple times in front of your board. So Hy-Vee tries very hard to work within your codes and so do we. And once in a while we run into one like this where we really don't think that there's any option but to proceed with this procedure. And so, what we think that they've requested, we hope is certainly non-detrimental and is in good taste, as I think the majority of what they do is. I think the fact that the signage that's up there now, which is quite a bit larger, there hasn't been, I don't think, any public outcry about that through the years, maybe speaks for itself. But I have myself and Ed on staff here that are also listening. If there's any questions regarding, any of the light outputs or the sizes or how we arrived at those or visibilities or anything like that, we're kind of on standby here for the board if you would need any of that expertise, and we appreciate your time. Thank you.
Thanks very much, Phil. Any other folks here to speak in support of this request?
Yeah, hello. This is Ed Pecci with Nesper Sign Company, 4620 J Street, Southwest Cedar Rapids. I was the one that was helping Hy-Vee on getting the permits and working on all of the calculations and so on and so forth with staff recommendations. Just kind of reiterate one fact that, we took the staff recommendations to heart. And we slipped underneath that in square footage of signage. The one thing that wasn't mentioned, was mentioned by one of the staff there, that the trees are fully grown on that west side, making it very difficult to see that sign on the west side, which is one of the reasons why we wanted to move that sign to the south side. I think the picture that you have is the one small window. Oh yeah, that shows a lot of it. But there is, if you go down just a little bit to number 7 there, I believe, shows a little bit of a window there on that west side, but that sign is much more visible on that south side. So once again, we slipped the sign square footage underneath the staff recommendations. And would find it much more beneficial to have that south side. So if you have any other questions on the square footages and that sort of thing, I'd be happy to answer. So thank you very much for having us.
Thank you, Ed, and appreciate your firm's work and attempting to adhere to our regulations here in the city and coming through the process. Any questions for Ed? All right. Anybody else here to speak in support of this request? If not, we'll turn to any speakers who are here to speak in opposition of the request. If you're opposed to this request by Hy-Vee, please raise your hand or hit *9 on your phone. Actually, I don't even know if we have any phone participants. Yeah, we
There's
do.
one. I don't see anybody raising their hand.
All right. And finally, we have a category for neutral. If you're just have some comments that you wish to share on this point, please raise your hand now.
I'm not seeing any hands again.
All right. Well, unless there are any questions for staff, we're not going to go into the rebuttal portion. That's sometimes allowed to the applicant because there is no opposition discussed. Any questions for city staff?
Yes, Vice Chair, this is Justin. For Eric, I'm just trying to wrap my mind around this. So what I'm understanding is for the appeal, the type 2 zoning exception would create some unallocated square footage. And that's why the city offered to do a third sign. And what the appellant is offering is to take that unallocated square footage and basically spread it to the 2 existing sign footage. Is that right?
Yes, but it's still requiring, the second one still requires a variance then.
If they would try to do that, right?
Yep. Right.
That's all I'm trying to figure out. Thanks.
Good question. Good clarification. Other questions for staff? Hearing none, I think it's time to turn to the board deliberation portion for item 2. Any comments to get us going here?
Mr. Chair, this is Cindy. Even though it sounds like this would still be a variance, I think they're taking the best approach possible to accommodate this request. You know, they're going to end up with the 2 signs on the north and south. They're taking the signs off the banner portion. They're not going to put a sign on the west side. I like the concession. It makes sense to me. I'm not sure what others think.
Other folks? Thanks, Cindy.
Vice Chair, this is Justin. Just that, we always struggle with these cases where we're trying to meet the variance test. And, my position's always been pretty much the same in that, there's a test for a reason. And we are our obligation is to kind of fit within that variance test and whether it's met or not. And so again, here, even if they do the type 2 exception and what the appellant's trying to do here it would create a variance. And so I don't think they would meet that variance test. So that's my opinion.
Thanks, Justin.
And this is Marlis. I would ditto what Justin just said.
Hey, Nathan, this is Dave.
Yes.
I'm going to go along with what Cindy was saying. They're doing a rebranding here. I think this Fresh Market, they've got these facilities around town. I know we struggle with this sign variance, and we're trying to do a one size fits all. I think the concessions that they've made, along with just some of the challenges of location, they're just trying to create kind of a sense of arrival for the customers. This is out in a parking lot of a pretty big strip area. So here again, I'm not too concerned about the variance, whether they need it or not. I'm trying to look at this thing from a business perspective and what's right and what we're trying to accomplish here for not only citizens, but also for these business owners. So I think that their request is fine. And I'm gonna propose that, we allow for it. So those are my thoughts.
All right. Dave, is that a motion on your part?
I don't want to make I'm happy to make a motion. I don't know if anyone else wants to weigh in and comment on it, but here
Sure.
again.
Well, I think the only person who hasn't spoken up is Lynn, and I should mention here, Lynn is gracing us with her presence for another month, which we all very much appreciate. She's rumored to be leaving us, but I'm glad that you've come back, Lynn. I don't mean to put you on the spot to
that's
voice your
fine.
opinion.
That's fine. I appreciate that. I'm along the lines of Dave. I mean, this board is here for a reason. If we just stuck hard and fast to the rules, we wouldn't have this board. And again, Hy-Vee is a very strong player in our market, provides a lot of jobs, and gives back to the community. And I am inclined to allow them, not the variance, but the exception level. So that's my thoughts. I think we should give them a little bit of leeway. That's what this board is for, is to take a look at the situation.
Thanks very much. So I think everyone's spoken except for me. Those who, my fellow members of the board, will not be surprised to hear this. And if other people in the audience, I'm sure staff are kind of sick of me saying this, but I'll echo a bit of what Justin and Marlis said. I understand that it can be frustrating because there are kind of common sense solutions or seemingly common sense solutions, but unfortunately the variance test is a very high threshold, which city staff read earlier. And I think I've maybe seen one sign request or maybe two over my course or my tenure here that has met that, but this one does not meet that. I would personally support the exception level requests that staff is recommending. I'm not totally convinced on the third sign. They don't seem to want it. So I don't know that we need to give it to them. But I would be open to that. And to put a Mel Penn's style comment on this, this is my, as a proud Southsider, this is my Hy-Vee. And so I'm looking forward to, have always appreciated the services they provide. And I think it looks nice. And I'm sure with the new signage, it will continue looking nice. Does anybody want to make a motion now, hearing that it frankly kind of sounds like it's a 3-to-3 style gridlock, but interested in hearing if someone has a motion to make to see how it tracks.
Mr. Chair, this is Eric. I am highlighting the piece that would change from, so staff is recommending the type 2 exceptions on both of the requests that they made. But if they're wanting to apply that full earning, the 63.75 square feet that they would earn with the first exception on the total, then to get 31.875 on each of those walls, it would actually be 31.875 over the 31.875 earned, and that would be the variance then. So that they're asking to adjust it to allow that total earning exception to be applied to each of the north and south walls, which would end up a variance of 31.875 over the earn amount of 50% to be applied on each of those walls instead of just divided amongst the
So
two.
it would be a total request of 63.75.
Right.
Yep.
So basically the full earning that they got in the first type 2 exception being applied to non-occupant walls, right?
All right. Thanks,
I
Eric.
just wanted everybody to understand that's what's being,
That's what the
that's how
applicant
they revised their
proposed.
request, and that they would drop the third exception.
Got it. Anybody ready with a motion? All right, then I'm going to move, hearing none, ready to jump in at least at this moment. I'm going to move that we deny the variance requests, but grant exception level requests for the two requests they made, both the total amount of square footage and the amount of square footage on non-frontage walls.
I would second that.
All right, so second by Justin. Other comments or discussion before we get to a vote? All right, hearing none, let's turn to a roll call.
All right, Lynn Carlson,
Aye.
Dave Gare,
No.
Justin Gross,
Aye.
Marlis Jones,
Aye.
Cindy Smith,
No.
and Nathan Blake.
Aye.
That motion carries 4-2.
All right, the motion carries 4-2. Thanks very much for everyone participating. I think Bree will probably hear from you again soon, and hopefully, Hy-Vee can move forward and accommodate. I think the city's done a good job of proposing something that'll fix, and the board has kind of acquiesced to that compromise. Let's move to item number 3. And Eric, is this you again?
Yes. Mr. Chair, members of the board, let me open it up a little bigger so you can read what's going on here. This is the location at 3221 Southeast 14th Street, another Hy-Vee gas location. In this case, they have a different scenario where they've got two earnings from 2 frontages as well. So they're able to apply earnings from 2 frontage walls to opposite or to non-occupant walls or transferred onto the fuel canopy. So in this case, they're asking, the original request was for a type 2 zoning exception of the total, basically the total square feet based on the signs allowed for the building, with the 72 foot of linear frontage along the East Park Avenue frontage, and then a variance of 44.36 square feet over the maximum 45 square feet of signage for a wall-mounted sign on a non-frontage wall. So they're exceeding the size which they want to place on the front of their entrance, but it's on a non-frontage wall. So this is, again, the parcel involves the overall commercial center. The area we're really dealing with is their site up in this location. This is looking from the south inside the commercial center parking area to the north. You can see the CVS sign across this East Park Avenue to the north in the background. This is moving a little further east and it's also still looking north. This is looking directly west at the canopy, and you can see the front of the building on the south non-frontage wall. This is the more directly at the frontage wall. This is looking at the East Park Avenue frontage wall. Right now, there's some pricing sign there you can see moving further to the west and looking more directly south. And then looking south at the west end of the building, so you can see the frontage that faces Southeast 14th Street. And you can also see the pricing sign on the canopy. This is the application submitted. I'll zoom in again. So they want the pricing sign to remain on the building on the north side, which does figure into the total area calculations. And then they want to remove the sign on the south non-occupant wall, which is the primary entrance to the store. This is the document, and then I will wait till Bree presents, and then she'll probably want to show the revised version. Then this shows that I believe that the canopy signs that would be removed, but they would retain these pricing signs right here. Again, figuring into the total area. There's no appeal here for number of signs. Moving through the staff report, staff looked at this with the same lens essentially, although this is different because of the scenario with 2 street frontages, the amounts and the actual appeals that they're asking for are not the same as in the previous scenario. We don't find that they meet the test for variances, but we do believe there's enough practical difficulty in their placement of their building within the commercial center at the corner with the entrance facing interior to the site, that the amount of their signage is certainly diminished based on the way it gets earned through the way it's earned through the ordinance. So while we're recommending denial, for the variances, we do recommend approval of an amended appeal for type 2 exceptions of 22.5 square feet over the maximum 45 square feet allowed for a wall mounted sign on a non-frontage wall. And then approval of the type 2 exception of a half square foot over the maximum 90 square feet of signage allowed for a building with 72 linear feet of building frontage. And so what happens is when you do that 22.5, it puts you at half a square foot over on the 90 square foot that they earn, if that makes any sense to anybody. By reducing the one sign, they nearly eliminated the need for the other exception, but there is a slight exception necessary. That would be subject to being installed in compliance with a sign permit issued by the Permit and Development Center to a sign contractor licensed by the city, and that the existing logo signs on the fueling canopy are removed as they have proposed. Cards received from nearby property owners. You can see them plotted on the consent map. I don't have anything further unless there are questions.
Any questions for Eric? All right, well, let's move in to hearing from the applicant. Bree, is it you again?
It is. This is Bree Cooper with Hy-Vee, Director of Retail Facilities. The address is 5820 Westtown Parkway, West Des Moines, Iowa, 50265. Thank you again for hearing this. We've taken the staff recommendation and reviewed the sign layouts, and we have accepted the recommendation that the staff has proposed. And so we have reduced the size of the sign to fit within the recommendations outlined in their proposal. And so we are proposing this version of it and would be happy to move forward with this version.
Excellent. Any questions for Bree? All right. Let's turn to seeing if there's anybody here to speak in support of the request. Seeing none. If you do want to speak in support, raise your hand, either through Zoom or by pressing *9 on your phone. Anybody here to speak in opposition of this request? Finally, anyone here to speak, I guess, with neutrality? All right, hearing none. I think I skipped Sue Ann last time, and I assume she didn't have any comments, but maybe I shouldn't have. The zoning enforcement officer, I don't know if there's any comments from you.
Chair, members of the board, I have no comment. Thank you.
Thank you. Any questions for city staff? All right, we'll skip the rebuttal because again, there's been no comments received that are in opposition. And we'll turn to board deliberation. Close the public input portion and any comments that folks wish to share about this particular request.
This is Lynn Carlson. Didn't the applicant say that they had reviewed what the city had recommended and now were agreeing to it? Or did I hear that wrong?
No, that's basically it. I mean, we will still have to, assuming we agree with the city's recommendation, and we'll still have to pass it. But it does seem like both the applicant and the city staff now are on the same page.
Well, then I would move staff recommendation.
There's a motion. Is there a second?
Nathan, this is Dave.
All right. Dave seconds. Any further discussion? If not, let's turn to roll call.
All right, Dave Gare,
Aye.
Justin Gross,
Aye.
Marlis Jones,
Aye.
Cindy Smith,
Aye.
Lynn Carlson,
Aye.
and Nathan Blake.
Aye.
Motion carries 6-0.
Great. Thanks very much. Turning to number 4, which is, I keep on forgetting to mention where each location is, although Eric's done a good job of describing it. So this is a zoning variance request at 1113 East Army Post Road. Eric?
Yes, Mr. Chair, members of the board. This is in a pad site at the Southridge Mall complex. It is on directly on the street frontage, so it does earn based on a long dimension of the building fronting East Army Post Road. This is triggering concern, or this is triggering the need to get variances of signs, number of signs to allow 4 over the maximum 2 wall-mounted signs, and then it's a zoning variance that would allow 111.22 square feet over the maximum 87.5 square feet of signage allowed based on their 70 feet of occupant frontage towards East Army Post Road. And then 65.61 square feet over the maximum 43.75 square feet of sign area that's allowed based on a non-frontage wall, which would be their south wall, based on that earning. So staff has looked at this. See if I can switch back out quickly to page levels. So this is their site, and it is on a separate parcel in this case. The main Hy-Vee store is over to the southwest, more internally to the mall complex, East Army Post Road frontage. This is looking at the existing scenario with the west side of the building, west side of the fuel canopy. Then this is the south side of the building and the south. So there's a channel letter sign and a fueling sign on the south side that's proposed, that's existing there. I believe they're proposing to remove the fuel sign and then replace the channel letter sign. This is looking at it from the east. They currently don't have any wall mounted signs, but they do have canopy signs. And then from the north, from the East Army Post Road, doesn't appear to be any canopy mounted signage, but they are looking to replace with their new branding on the front occupant wall of the building. This is their application. I'll zoom in a little bit here. So this is, they're trying to remove the existing front facade along Fleur and install with their new, and then also remove their existing on the backside, the fronts, the non-frontage wall, non-occupant frontage wall that faces the mall complex. This is the rendering of what would be proposed. And I believe this is on the south wall. And then, as I had indicated, they're looking to remove the pricing on the south facade. They are looking to maintain the pricing signs, as well as having the front facade and south non-frontage facade with that. So they would still be proposing 4 signs. This is the staff report you received in your packet. Staff is recommending that we deny the variances again based on the finding that there isn't a demonstrated unnecessary hardship, but we are again looking at the practical difficulty aspect of this, given changing existing sign areas and allowances based on new branding and the positioning of the building within the center of the mall complex. it does earn off of one frontage, but there is also a need, I think, to be exposed and direct signage to the mall itself. Staff is recommending approval of amended appeals for type 2 exceptions to allow 3 wall-mounted signs, 1 over the permitted 2, and to allow proposed total sign area to be 43.75 square feet over the maximum 87.5 square feet earned, for a total of 131.25 total square feet. And then to allow the sign on the south non-frontage wall and canopy combined to be no more than 65.625 square feet in total area. Which is half of the amount that they would have earned with the recommended type 2 above, but being placed on a non-frontage wall and canopy. These are subject to the following conditions. Any signs shall be installed in compliance with a sign permit issued by the Permit and Development Center to a sign contractor licensed by the city. Existing logo signs on the fueling canopy and the digital pricing sign on the south facade of the building are removed. Now, the other thing that comes out of this is if we're recommending 3 wall-mounted signs, they will have to decide on a canopy sign that would need to be removed on their pricing as well, in order to get 3 signs, assuming they want the 2 mounted on the building, but I'll let them speak to that. But I did want to point out that we didn't want to condition which sign they wouldn't use in this case, but they will, to follow the exception, they will have to have they would be limiting to 3 wall-mounted signs. Are there any questions at this point? So this is we did not get any written comments on this.
There was something in the bill about that last month, so I forgot.
Any questions for Eric? All right, turning to the applicant.
Thank
Bree?
you again. This is Bree Cooper, representing Hy-Vee, Director of Retail Facilities, 5820 West Town Parkway, West Des Moines, Iowa, 50265. Thank you for hearing this out. Again, we have reviewed the staff recommendations, and the existing sign area was reevaluated and reduced in sign to fit more in line with the calculations necessary to fit within the Des Moines City Ordinance. We are planning to remove the pricing sign from the building, but would like to include both pricing signs on the east and west end of the canopy. However, all of the logos would be removed. So as we've been walking through this, we've agreed to remove logos. We feel that pricing signs are an important part of the gas business, which would be a critical part of this sign package. So removing the one from the building is a concession that we can give, but we'd like to maintain those 2 pricing signs on the gas canopy at a minimum. So in the end, we still want to have what the staff is calling for 4 wall-mounted signs on the building, even though they're all sort of different signs. So we can concede with sign areas, but we'd like to maintain 4.
All right. So as just to kind of reiterate what I think you just said is you're okay with city staff's recommendation with respect to the area that they've recommended, which is at an exception level rather than a variance level that you had requested before. But you're still interested in the variance request to allow for 4 signs rather than 3 signs, which is what staff is now recommending.
Correct. And you can see that in the pictures on the screen right now. We've got the front face, which is a smaller square footage area than what was in your packet. Page 2 shows that that was reduced as well. And then page 3 shows the removal of the logo signs on each end of the canopy. So yes.
All right. Thank you. So I do have an additional question, and just not to put too fine a point on it, but the reason that the item number 2, at least speaking for myself, for the reason why I didn't support that variance request is because it didn't meet the variance test. And the variance test is pretty specific. You have to establish all 3 elements of unnecessary hardship. A couple of them, frankly, are a little bit in the eye of the beholder, or at least one of them is the use that it's not going to alter the essential character of the locality of the land in question. The second one, the plight of the owner is due to unique circumstances, not of the owner's own making, which often occurs. But the third one, listed first here on the page that's up on the screen, is that the land in question cannot yield a reasonable return from any use permitted by the regulations of the district in which the land is located. And the description here gets more specific. It's not just that the value of the land has been depreciated by the regulations of the city, or that a variance would permit the owner to maintain a more profitable use. It's that you have to show that the owner has been deprived of all beneficial or productive use of the land in question before it meets the variance test for this request. And so I guess my question is, how do you get around that, or how do you address that with this particular request of 4 signs rather than 2, or what the city is recommending 3?
It is, signs are an essential element of how this property is doing the business. So pricing signs is and has been a standard use of gas station properties in the areas. And so they're there now. And from the existing conditions as a criteria that we're evaluating the property and what it's being used for, should be a way to evaluate how we're looking at the variance request moving forward. So we're not asking for it to be depreciated. We're just asking for it to be maintained in the same status that it is currently. I'm not asking for more than what was there previously. I'm just asking to be maintained. We're not asking for even the sign to be changed. It's an existing sign. And so this fact that the city staff has called out the pricing signs to be a change from what was there existing is part of what we're struggling with. That is the reason for the variance. We had gone in and all the logos had been removed, which met with what we thought was the intent of the change in your ordinance, not anything to do with the pricing. So that's kind of where we're struggling with, why would that even be included in this since it's already there as an existing condition?
Other questions for Bree? All right, we'll move to the public participation and start with folks to speak in favor of this request, in support of this request. I see Phil has his hand up. Name and address again, please, Phil, once you unmute. You'll need to unmute if possible, Phil.
There we go. Is that better? Sorry.
It is. Yep.
All right. Sorry. So you didn't hear any of that, did you?
Did not. Sorry.
Okay, sorry. Phil Garland, it's PhilGarland. I'm president of Nesper Sign Advertising, 4620 J Street, Southwest, Cedar Rapids, Iowa. I just wanted to address a couple issues here in regards to the variances and the criteria for variances. And I've been doing this close to 40 years now, and I've helped write many of the sign codes throughout the Midwest, to be honest with you. And obviously on a daily basis, this is kind of one of the things I do is talk to groups like yourself and city councils all over the Midwest. And it's always kind of a bit of a struggle, and especially with signage. Just a couple points. One is sign variances or sign codes in general are pretty much put together by ad hoc committees. They're not as scientific as, let's say, a fire code where they can say a certain temperature and something catches fire, etc. They really aren't scientifically put together. They're just kind of, we like this, we don't like that, we want more of this and less of that. And they kind of get these arbitrary numbers together. And when we get all done, it becomes kind of a chisel and golden tablets. And that's really, I want to be to make aware of that these aren't necessarily quantifiable. This is good, this is bad. They are very arbitrary, and they're very hard to put against different size properties, et cetera. I know you people know that, and I know you're involved with it every day and have an appreciation for that part of it. When it comes to that variance test, that was out of some Supreme Court tests that were really for variances that were not sign variances, but they were property variances. And the one thing that overlooks that is unique with sign variances is that there is a free speech element of signage that is not whether my garage is 5 feet back in the property line or 4 feet or that sort of thing that gets involved in property cases. There is this right of a client to have commercial speech. And again, I know you guys are aware of all this, but that element really, if the government body is going to take that a reasonable approach away from them on that, you're denying them a right. And I know we all hold our rights very, very dear. And I know you do too, or you wouldn't be volunteering for something like this. And so I don't mean to imply that in any way, but I do think that needs to be considered when you're getting in with this, very, very strict adherence to a variance set of criteria that is really based on property type things, and it does not account for that part of it. And so I would ask you just bear that in mind a little bit with a client that is, I think, very, very hard trying to work within this thing. The last thing on the gas price signs that I find across the Midwest or that in our trade area is that by and large they're required to post prices. That's a big thing in that industry, and most, I don't know if that's state regulation or federal regulation, but they're required to do that. So many municipalities don't even count the pricing signage part of it. It really isn't advertising. It is a public service requirement to them. And so they're kind of in a catch-22 there is, hey, you can post your price, but you can't do brand. I just throw that out there again, as I think for something unique. If you're looking for a reason to grant them and to go with what city staff has thought was reasonable in this case, I think there's 2 or 3 things there, hopefully, that I've thrown at you that maybe you can see as something a little bit more unique with this property and or with this circumstance especially. Thank you very much for your time.
Thank you, Phil. It looks like Ed. Any questions for Phil? Looks like Ed has his hand up. Also to speak in support, I assume.
Yeah.
Oh, you want?
Can you hear me?
Yes, sir.
Oh, hi. Thank you. Yeah, this is Ed Pecci, Nesper Sign Company, Cedar Rapids, Iowa, 4620 J Street, Southwest, Cedar Rapids, 52404. One thing I wanted to mention on the digital price changers also is, I always think about if I was trying to get gas in Des Moines and I'm driving north on Southeast Widget Road, and I'm looking to the left and seeing the gas station, but I don't see any price changers. or I'm traveling east on Army Post Road doing the same kind of thing and not seeing any price changers, it really makes it difficult for a gas station to operate when patrons can't see the cost of the gas that, you know, they're looking to get gas. So that's one thing. And also, you know, you're always talking about safety, or at least we are always talking about safety and the ability to see things. You're driving on a busy road. Des Moines is always busy, and you know you're stretching and looking for the price on the gas station. So I just wanted to kind of look at it, give you a look at it from a patron's point of view, and how difficult that would be. If there was only one of those signs, you're really missing half of all the traffic. So that's it. That's all I wanted to say. Thank you very much.
Thanks very much, Ed. Anybody else here to speak in support of the applicant? Anybody to speak in opposition? Anybody that just wants to be heard? Zoning enforcement officer, any comments on this one?
I have no comments on this one. Thank you.
Thanks. Turning to questions for city staff, there were some legal items that Phil brought up. Judy, I didn't know if you had any comments on that or any clarifications for the board.
I do, Nathan. Thank you. This is Judy Parks Cruz, Assistant City Attorney. I appreciate Mr. Garland's comments about the nature and the source of some of the requirements that relate to variances. I can elaborate on that just a little bit. 3 of these were placed in the Iowa Code, and then because of subsequent court decisions, specifically talking about the unnecessary hardship test, we have additional guidance from the courts that says we have to look at whether there is going to be any economic use of a property if a variance isn't granted. It's not whether you can make more money from it or less money from it. It's whether it loses basically any kind of use you can have on it. And it is a very high test because what the court has said, what you are doing by a variance is allowing someone to do something that the code, and in this case, the ordinance, prohibits. So that's a really high bar to meet. And it is not limited to use variances. It also is something in this state, Iowa, that applies to area variances. So free speech is one of those things that was mentioned here. Yes, I appreciate, and we are very cognizant of signage regulations, not touching on content, but when they touch on the amount of signage and do not speak to what that signage says, we are permitted to adopt reasonable regulations. And that's what we have done here. It may seem like it's a very hard or high bar to meet, but it actually is. You're not misreading that. So that's why we have to keep going back and looking at what the evidence is that has been presented that shows all economic use is lost. And that was what was requested in some of staff's questions, or excuse me, some of the board's questions to the applicants, witnesses.
Thank you, Judy. Other questions for staff?
Mr. Chair, yes, Justin here for Eric Lundy. The only point that I think is worth sort of asking a little bit about is that pricing is considered a signage. Can we have a little historical context about that? I mean, why is, I guess, the pricing considered a sign? Or
yeah, in our ordinance, in the previous ordinance, neither treated pricing as something different that was not calculated as part of signage. So it did give the flexibility in the old ordinance and in the current ordinance to transfer earnings to the canopy from what's earned off the building, similar to the way it's allowed to be transferred to the non-occupant frontages. In some districts, the digital aspect of it is also limited. I think that isn't the case with this particular situation. And I think we've sort of tried to get a little more contemporary with our current code to the business models that you see with things like convenience stores or banks or something of that nature. So, but we do count them as a separate sign, and we do count them as part of the earnings in terms of the area as well. In this case, staff looked at the standard of the total signs and thought that we could support the exception level for the number of signs. In that situation, we did not want to dictate that they remove one or the other pricing sign, or, you know, just allowing 3 signs with the earnings at the exception level. If the pricing would be the most important aspect, they would retain that, and they could use the exception level of area on the front sign and remove the rear sign, for example. So we didn't want to dictate how they use that number of signs directly.
Thank you.
Thanks, Justin. Other questions? All right. Hearing none, there were no speakers in opposition to the request. So we'll move to board deliberation. Comments or positions on this particular request, item number 4.
Hey, Nathan, this is Dave.
Yes, sir.
And I guess I make comments as I did earlier in the meeting with regards to the other sign request. I think this is very reasonable. I think we're splitting hairs when we start talking about what's allowed, what's not allowed. I'm not a real fan of this. And I know some people are strict on the variance. I don't happen to be as strict on the variance. Here again, I'm trying to think of something that makes sense. And we've got basically a national brand in Hy-Vee. And I feel like that we're being pretty restrictive for a pretty reasonable request, in my opinion. So I'm in a position where I grant their request, but I'm interested to hear what everyone else has to say.
Thanks, Dave. Others?
This is Cindy. I agree with Dave on what he said.
Thank you, Cindy.
Vice Chair, this is Justin Gross. If I may just speak on this, and kind of along the lines of what's been already stated before in the previous items that we've mentioned about today. The Iowa Supreme Court this year put out a opinion kind of in regards to the variance test, and I'd encourage the other board members to maybe look at it. It's Early versus the Board of Adjustment of Sierra Gordo County. And the point I want to make, and I'll just read a little bit of it, it just says the board's statutory authority to grant a variance is limited. It is fundamental that the board may not legislate. It exercises only the administrative and quasi-judicial power strictly within the limitations of the statute. And so I just bring that up just to the board members, just because, again, and I know I sound like a broken record, but I always look at that variance test, and it is a high burden to meet. And so we, as a board, have to be within the limitations of that statute. So I would be in favor of denying the variance request and recommending the staff's recommendation of the type 2 exception. Thank you.
Thanks, Justin, and appreciate you bringing up that case and the homework assignment for all of us before maybe next month. Other comments from folks or any motions?
This is Marlis. I'll make a motion. I recommend that we deny the requested zoning variance, and we recommend the approval of the amended exceptions.
All right. Marlis has made a motion for staff recommendations, essentially, right? Any second?
I second that.
Thank you, Justin. Additional discussion before we go to a vote. All right, let's do the roll call.
All right, Justin Gross,
Aye.
Marlis Jones,
Aye.
Cindy Smith,
No.
Lynn Carlson,
Nay, no.
Dave Gare,
No.
and Nathan Blake.
Aye.
So we got a tie, 3-3.
All right.
Um,
Well, unless there's another motion.
And Mr. Chair, this is Bert with the city. I would point out that it takes 4 affirmative votes for any appeal to pass. So if the board were to grant any exceptions at all, it would take 4 affirmative votes. So right now, no appeals would pass.
Which would mean that they'd be required to adhere to the strict guidelines that the city has in place right now.
That's correct, unless somebody makes a subsequent motion.
Any members of the board wish to make another motion?
Can I speak to the board at this point?
No, I'm sorry, ma'am. The time for public input is over.
This is Bree Cooper.
Yep. No, I'm aware. Yep, I see.
Okay, all right, good enough.
Sorry.
Thank you.
Yep.
Want to check.
And Judy, are we allowed to have the same vote over? I guess I not to put folks on the spot, but I assume that the 3 people who voted against it, just based on comments, prefer an even kind of more accommodation being given to the applicant. But if right now what is going to stand is that the applicant's going to be far more restricted in their ability to develop signage for this property as it stands. So
yes, I agree with you. I was looking at that myself because the original motion included both the denial of the variance as well as the grant of the exceptions. It incorporated everything that we could do at this point. And the flip side of that, which would be not voted probably favorably, would be to grant the variance, but I cannot see that would be supported in a different numerical breakdown of the vote.
right, and we certainly could try that. I guess my question is whether any members, either those who voted yes or no, could remove essentially the same motion and get and hold the roll call again, or if that's not an option to us at this point.
Well, typically it's not unless there's some change in circumstances. I am looking real quick at what our provisions are, and I will apologize, I have an old set of the rules in front of me. I guess, given the breakdown, I would maybe entertain if anyone wishes to change the vote. So we do have a situation where at least the applicants would be able to get some relief, or would they?
So maybe a way to handle it, assuming this is legal, and Judy, if you find out otherwise, please let us know, but is if any of the 3 no votes wishes to reconsider their vote and propose that same motion that was just voted down, or hope springs eternal, I suppose a different motion could be considered. But I'll give a few seconds for folks to jump in if they want to do that.
So we can make a motion to do a revote?
So what was denied was the staff recommendation.
Mm-hmm.
I don't know if, I guess I'd ask Judy if another motion different from the staff recommendation would be able to be put on the table.
Well, yes, you could. I don't know how it's going to be a great difference from the staff recommendation, which is denying the variances and then granting the type 2 exceptions. But yes, you can do something different than what staff has put in there.
Hey, Mr. Chair, this is Cindy. To move this along, I don't want to have it more restrictive for the applicant. So I guess if I need to change my vote, I'll do it. But it's frustrating because I'm not sure why variances are even brought forth to us at all, if there's never an opportunity to discuss it and vote it down. Just my personal opinion. It's very frustrating, but I certainly don't want to make it more restrictive.
I'm with
That
you on
wouldn't- Yeah, that's not my intent at all.
Do you have an alternative? This is Judy Parks too. Do you have an alternative motion that you would put forth, or you just would like the same relief that was granted, and knowing that we need to have 4 votes, you're willing to change your vote?
I'm not sure about an alternative motion. I just see the need for 4 signs, but if that's not workable at all, then I would just need to change my vote.
All right, so we're somewhat dependent on staff here to make sure we handle this correctly. Thank you, Cindy, for voicing that, and it sounded like Lynn spoke up as well. But I want to make sure that we're doing it correctly. So if we're able to either open up the previous vote or to move the same vote, move the same kind of motion, which was staff recommendation, I think that would be the simplest way to go. But if necessary, I think I could probably come up with another solution.
Well, this is unusual because I don't know what additional or alternative sort of motion would be acceptable. Probably if no one has any ideas besides what is placed in front of them in the staff recommendation, then, and knowing that sounds that there is a concern over the result, meaning a much stricter compliance is required of our applicant, then what I would suggest is put it to a vote again, and I guess make a new motion renewing what has been placed in front of you, and we'll see if a different vote is resulted. But if we could get a motion and a second of that and go forward with a roll call vote again, that's the guidance I would give. We don't actually have anything specifically speaking to this in the rules, so.
Okay. I mean, one way to handle it, Judy, oh, it looks like Sue Ann has her hand up.
Well, I was going to ask a question if I can. Would it be possible to do a motion to set aside the previous vote and then a new motion to a new motion to be considered. Would that be procedurally correct?
That would make a very clear record of what's being done. So I am all ears, because this is not something we typically see happen. So I would concur with that.
All right. That's a good suggestion. Thank you, Sue Ann.
Yes, thank you.
So I'll move to, I can't remember the word you used, Sue Ann, void or
set aside
the previous motion and vote. Is there a second?
I'll second that, Nathan.
Thank you, Cindy. Any discussion? All those in favor, listen to Tyler as he does the roll call.
All right, Nathan Blake,
Aye.
Lynn Carlson,
Aye.
Dave Gare,
Aye.
Justin Gross,
Aye.
Marlis Jones,
Aye.
and Cindy Smith.
Aye.
I pass it 6-0.
All right. So we were still hearing item number 4, the variance request. I will move denial of the zoning variances and approval of the type 2 zoning exceptions as recommended by staff.
I'll second.
Thank you, Cindy. Any other further comment? Hearing none. Tyler, another roll call.
All right, Lynn Carlson,
Aye.
Dave Gare,
No.
Justin Gross,
Aye.
Marlis Jones,
Aye.
Cindy Smith,
Aye.
and Nathan Blake.
Aye.
So the motion carries 5-1.
All right. Well, appreciate the board's working through that. Bree and Ed and Phil, appreciate your patience with the process this afternoon. Hopefully you're able to work with what we've addressed and look forward to seeing the results in the future. We'll turn to item number 5, which is yet another sign variance request, zoning variance request at 3610 and 3660 Merle Hay Road. Who we'll start with?
It'll be Bert.
Right?
Yep. Sure. Thank you, Nathan, members of the board. This is Bert with the City of Des Moines. Number 5 is a request from the McDonald's at 3610 Merle Hay Road. And they did withdraw a portion of their appeals yesterday. So today we're only considering the appeals for 4 wall-mounted signs on the building, and then the appeals for 4 signs appurtenant to a drive-through use on the site. The appeals that would have allowed for 4 driveway signs have been withdrawn. The subject property is located on the west side of Merle Hay Road, just to the south of Douglas Avenue. Here are a couple of photos. You can see that the McDonald's is currently under renovation. So they would be adding 3 signs on this east facade, and then 1 on the south side facade facing the parking lot. And then they would also be adding a total of 4, or installing a total of 4 drive-through signs in this area here to the north of the building. So here are the signs that they're proposing on the building. This sign here is what would be located on the south facade facing the parking lot. And then these are 2 of the signs that would be on the east facade facing Merle Hay Road. And then the 3rd sign on the play place also facing Merle Hay Road. This total signage area is within their allowances. So the appeals for the wall mounted signs are really only to have 2 more than the allowed 2. So it's a variance of 2 over the allowed 2. And the spoiler alert, staff is recommending denial of that variance, but approval of a amended appeal for an exception of 1 overly allowed 2, which would allow them to have a total of 3 signs. As I mentioned, they're also proposing to have a total of 4 drive-through signs. 1 would be, or 2 would be menu boards, and then the other 2 would be cantilever signs that go over the drive-through. This is the first display board that would be installed. And as you can see, they're not proposing a monument base. So these 4 signs for the drive-through use also require a variance of the provision that requires any freestanding sign to be a monument sign with a minimum 2-foot tall masonry base. This is the second menu board sign. And again, it also would not have a masonry base. And then the other 2 that are over the drive-through lane look like this. This is the first one that would direct drivers to the drive-through lane. And then the 4th sign here is actually their ordering station. So you can see the built-in microphone is within this post here. So as I alluded to, staff is recommending denial of the variances. We don't feel that they've satisfied the criteria necessary for granting a variance. As you well know, in order to grant a variance, you have to prove the unnecessary hardship, which finds that there's no other economic use of the property without it. So we do feel that it's hard bar to meet, but we have recommended approval of the maximum type 2 zoning exceptions that could be considered. Those would be the exception of 1 wall-mounted sign over the maximum allowed 2 wall-mounted signs. And then we've also recommended approval of an exception of 1 sign appurtenant to a drive-through use over the maximum 2 signs appurtenant to a drive-through use. And the 3rd sign, or the 3rd appeal here, is not necessary since they withdrew those signs yesterday. So we only received 1 comment card back, and I'll let you read it here. It's kind of in neutrality. Yeah, as you can see, they didn't mark whether they're in favor or in opposition. They just mentioned that they live behind the signs and are concerned about noise from the ordering stations. So did anybody have any questions for me?
Any questions for Bert? Bert, just to clarify again, the variance requests just have to do with the number of signs in each of the categories, not the total area.
Correct. Yes. Okay. In both instances, the appeals there's only 1 appeal needed for the wall-mounted sign, and that is a variance of 2 over the allowed 2. And then for the signs appurtenant to a drive-through use, they need 2 different appeals. One of those is for a variance of 2 over the allowed 2. And then the second is the variance of the provision that requires any sign that's visible from public right-of-way to be a monument sign with a minimum 2-foot tall base. So we have recommended denial of these 3 appeals, but recommended approval of the maximum exceptions, which really correlate just with these first 2 variances.
All right. If there's not any questions for Bert, we'll move on to the applicant or representative of the applicant. If you could raise your hand.
I believe Miranda Cassin's there, she has raised her hand, so she'll be representing McDonald's.
Great. Name and address, and you've got 10 minutes.
Hi, I am Miranda Cassens with Chestnut Signs, located at 971 Northeast Broadway Avenue, Des Moines, Iowa, 50313. A few items to note on the brick bases I had included in the application. I did not realize until now that I did not see it in this staff report, but we are requesting a type 1 exception to allow alternate durable materials for a monument sign base. So on that one, it's more just we're requesting to not require the brick base because this is kind of a brand standard for McDonald's. There's multiple other McDonald's in the metro, including in Des Moines, where they've used this look on their drive-through elements. And so in order to keep things consistent, recognizable as McDonald's, they'd like to go with the aluminum and steel materials that they've proposed as their durable materials for the monument base. So that I would like that to be considered. I'm not sure if that can be added at this point. Again, it was kind of in the letter and some of the paperwork, but I didn't realize until now that that was not included in the staff report here. So
sure.
Okay.
Yeah,
and then on to, oh, go ahead. Sorry.
I was going to say, sorry, this is Bert. I can address that. Since the appeal was noticed as though for a variance, as though you were providing no base on those signs, it would be under the board's authority today to consider a type 1 exception.
Okay.
Where you would provide somewhat of a base, just not the 2-foot tall masonry base.
The other item I wanted to address is on the signs appurtenant to a drive-through. The two items that are causing some concern is the sign 7 clearance bar. So our concern here is, yes, it does say drive-through, but the main purpose of this is not so much to direct people to the drive-through. It's more a safety issue with clearance. So I can discuss with McDonald's, but if we were to remove the word drive-through and still have this just be a clearance bar, would that still be considered a sign? Because this is more key so that people don't drive too large of a truck through the drive-through and end up taking out their truck, taking out the canopy, possibly injuring themselves or the staff at McDonald's. So the main key of this item is purposeful and not really a sign to like say, hey, we're McDonald's, come to our drive-through. It's let's be safe, let's go through here, let's not bring equipment through that is more than 9 feet. So that's on that one. And then the order here again is not really, again, what I would consider a advertising sign or anything like that. It is more their equipment for ordering. So if we were to take off the larger order here, I don't know if McDonald's would be willing to do so because again, some people might be confused and not know where to order, but I would like almost to ask this to not be considered a sign because it's more equipment that is needed for the use of a drive-through. Without an order canopy with a speaker, their drive-through can't take orders. So that is the consideration there. As far as the wall signs, I do know McDonald's would most likely be willing to accept the 3 signs that the staff has recommended and not have 4, even though they had originally requested 4. So they're willing to move on that item, but the drive-through elements are pretty important to them. So that's kind of where we are there. I do believe Christine with McDonald's is here, hopefully in the meeting, and she may be able to speak a little more to the use of this equipment and the importance of it to their company.
Thanks very much, Miranda. And I'll just note, we'll let city staff weigh in. I think there has been in the past some differences of opinion about sign definitions when it comes to drive-throughs with respect to the board and maybe what staff has recommended from time to time. So, but staff, I don't know if you're able to, and whomever can speak up.
Right.
I guess we'll start with you, Bert.
I would defer to Sue Ann, but
okay.
Anytime that there's text, we really consider that a sign because
but
we're not
how
allowed
about like the first one.
Right. So yeah. Because we're not allowed to control content of signs. So it's either a sign or it's not. So we either look, if there's wording, we just call it a sign.
Yeah, but if it didn't have drive-through and it just said clearance 9 feet, would that still be considered a sign? That seems.
It looks like
some-
Sue Ann.
I'm trying, Chair, members of the board, trying to think this through with you. Seems like they could have appealed, but they probably didn't know that we were calling it a sign until they got the staff report. And I think if they're going to appeal the decision that that's a sign, they're going to have to stop and have this hearing renoticed and then have the board weigh in on whether or not you agree that that is a sign.
So I think what I'm hearing Sue Ann say is that we're still calling this a sign, but
Yeah, no, I understand that as a kind of a predicate position, but her question was specifically about removing the words drive through. And if that would make it not a sign, it sounded like that was a possible approach for them that they could do. And presumably then we could even allow the other sign, right, to be considered a sign. But
Yeah.
Sue Ann, it sounds like
I'm
you'd
trying to
still consider it
decide
a
what
sign.
else we would call it. If you take the drive-through off, does it have any microphones or any?
No, it's basically just a clearance bar to ensure that people don't hit their canopy, because it's a lot cheaper to replace that little bar than their entire canopy on their building.
Right. I guess I would say if the drive-through came off, it's over 3 feet tall, so it would be Bert, help me. It can't be an accessory structure, can it?
yeah, I mean, the only allowed accessory structures would be like a gazebo,
right,
or a storage shed, and this wouldn't meet either of those definitions.
I'm wondering, this is Judy Parks Cruz, is it, it still talks about signage, but we do have a category of signs required for public safety or governmental interest. And I think of signage when I'm like bridges and those kinds of things, which simply have a height designation so that you don't have vehicles too large going through. I wonder if it can be categorized in that manner. But again, it still falls as a sign.
Right, it does then become a warning sign.
Right. It's a little bit awkward when we're asked to negotiate in the middle of a meeting, because it sounds like they have some different thoughts about how to approach this, but we really deal with a fixed application because that's what we are required to give the public notice of. So the idea that if there is some different proposal that comes along in the moment, that is harder to deal with in this kind of setting where we actually have to give advance notice.
Sure, I'll just flag for you. I mean, I think there's some. I mean, and I've seen this happen in the past, and I hesitate to describe it with any sort of real specificity, but there's almost like a jury nullification approach that the board sometimes takes to determinations that are made when sign requests that we find, or determinations that are, some things are signs, whether they be drive-through or murals, rather than going through the process of having these people come back again and renotice it and spending all of our time again in a month, we just, it's just been granted. So I just raise that. I understand that folks don't want to necessarily propose compromises just here on the spot, but I just raise that as, sometimes the board views this differently when that we're looking for a solution to something that we think shouldn't be a problem.
Yeah, that's an excellent analogy.
All right, Miranda, sorry, we've started to answer some questions, I think, that you've posed, but maybe have prompted some other comments. I just want to give you a couple more minutes to finish up if you have anything else.
No, that is all I had on this. Unless anyone has any other questions about any of the other signs or items requested. I guess I do apologize. One other thing was on the location of the drive-through elements. If you could pull up that map. Due to the garbage structure, we do have a differing opinion of if you will actually be able to see number 8, the order canopy, and number 6, the order outdoor digital menu board from Merle Hay. When writing the variance, I told them that we would ask for a type 1 exception on all just in case, but McDonald's themselves does not believe you'll be able to see those items from Merle Hay when you're coming south. Obviously, sign 5 and 7, you can see because they're not behind that garbage structure. So that's something else just to add to the conversation.
All right. Thank you very much. Any questions from Miranda? Okay, then we will turn to the public portion. Anybody here to speak in support of the applicant's request? Not seeing anybody here to speak in opposition. And a reminder, just raise your hand on the Zoom, or if you're on your phone, hit *9. Finally, anybody here to speak neither with support or opposition, but maybe to comment on this in neutrality somehow. All right, so Anne, you've weighed in once already, but any further comments?
Chair, members of the board, I don't really have any other comments. I don't think staff agrees with the position that those signs are not visible. So I would just ask you to keep that in mind, that we believe those should be monument signs.
And then, okay, thank you. And then questions for city staff. I actually have a couple related to that particular point. One is, our type 1 exceptions are handled normally by staff, right? Or they're allowed to be handled by staff. Is that correct?
That is correct. They're eligible to be approved administratively, but the board is also authorized to grant them as well. So it's under your purview.
And could you, with respect to the monument, and apologies if this is in the documents you've already sent along, but with respect to the monument sign requirement in particular, could you describe what the type 1 exception would allow?
Yeah, I'll read it to you. So in chapter 134, I need to pull it up real fast. In chapter 134, section 6.5.2, it lists 9 different types of appeals that are eligible for administrative type 1 zoning exceptions. And the 4th one listed says exceptions to allow alternative durable materials for a monument sign base. So that's if they wanted to like install a metal skirting beneath the entire sign that's at least 2 feet tall. That would be eligible for a type 1. I don't know that staff would necessarily support that, but the board can most definitely grant that today. But in order to, it still says it needs to be a monument sign base. So it just says exceptions to allow alternative durable materials for a monument sign base. So
it would still have to be the width of it, the full width.
Yeah, it still has to be the full width. So what they were showing was more or less a pole sign. It was wider than an average pole, but it's still considered a pole sign, since the pole didn't, fill out the entire width of the sign.
Okay.
But I guess we should have Miranda confirm that that was her intention, was that the entire area beneath the sign would be filled in with a metal panel. Is that what you were thinking?
I did not have the alternative. McDonald's had just asked me to see if they would be allowed something differently. So they would have to draft something up differently than what they're showing.
Yeah, so if you can see where the cursor is, this entire area here would have to be filled in with some durable material.
Some sort of cladding.
Yeah.
Okay.
The same way with bigger sign, the entire area beneath the entire width would have to be filled in with some sort of cladding.
Okay.
And Bert, any move away from the width requirement would require a variance?
Yes, then it becomes a variance.
And how about the height requirement?
Well, another type 1 that's so the fifth item on the list of 9 eligible type 1 exceptions is an exception to allow less than or equal to 50% variation in the height of a monument sign base.
Okay.
So
and
anything anything between 1 foot and 2 feet can be granted as a type 1 zoning exception.
And I don't see the measurement on here. I was, I guess, a little confused about whether they were requesting that part to be changed as well. Miranda, are you able to answer that?
I believe these are a fairly stock item for them, so they will most likely be requesting the reduction in the height of the base.
Okay. All right. Other questions for staff? I've asked plenty. Okay, and Miranda, thank you for offering some additional color and answers there. We didn't really receive any comments in opposition, but if you have any kind of closing statements, just because obviously there is some opposition that's been voiced, and we've had kind of some back and forth. If you have anything to button up, we'll give you a few minutes to address that before we move into our deliberation.
Yeah, thank you again just for hearing these requests. I'm not sure if it would be worth voting on different items separately in case some people didn't want to approve part of it or not part of it. If we could look at like the amendment for the wall signs as one thing, where maybe the addition of the drive-through signs is another thing. So it's not just blanketed. That way, if someone didn't want part but was okay with the other, they could get at least part of it approved. I do know, since it is currently under construction, they're basically waiting for this meeting to be commenced, and then they will be putting the signs into production and shipping them. So I know time is of the essence of them. So ideally, if they do not have to come back to another meeting to request different things, it's going to be super helpful for them. So that's why I ask if there is a way to split the recommendations up, that would be great.
Yep. Okay, appreciate that. And we are able to consider things independently or make kind of grants one set of variances requests and deny the other ones, et cetera. So, yep. So, all right. Any other questions for anybody from the board before we go into deliberation? All right, let's move into deliberation. I'll just note kind of for the record, Dave had to depart at 3, so he's not able to join us. So that leaves 5 of us to decide the last 2 items. Any comments here to get us going?
Mr. Chair, this Cindy, my recall is that we looked at a similar situation on Fluor for McDonald's for monument signs versus the pole sign. And I was thinking that we passed we approved for the pole sign, but I could be way off on that. I don't know if staff remembers or not.
I do remember those going to the board, but I don't remember the outcome. I can try to look it up real fast.
Yeah, that might be helpful. I kind of remember that too. And I remember there was some like venting issues that came up. I do think it sounds like we have the discretion to pretty easily allow for both a reduction in height if needed with a type 1 exception request, but also a change in the material they're using, which I personally don't have any objection to this alternative material that they're using, especially since it's kind of fits with their what they use in the rest of the state or the kind of metro area. My feelings, just to respond a little bit on these signs, is that they're not signs. I understand that city staff disagrees. It does seem like in this case, we do have an opportunity to maybe figure out a solution either through variances or I felt like McDonald's was being, or Miranda, their representative, was being pretty flexible with respect to the drive-through items. And maybe, I'm not sure how we could proceed there, but I'm open to hearing suggestions. On the wall-mounted signs, I don't think they've met the variance test, and I personally wouldn't be supportive of that, but I think having 3 wall-mounted signs as an exception level request is appropriate. So I would support that. For the 4 drive-through signs, I question whether a couple of them especially should even be considered signs, given their purpose. And I'm certainly open to kind of suggestions on how we might address that as a board. I say that as a sign variance hawk, as we've kind of devolved into a couple different camps here.
Right.
That would be a good idea to do something like that, because I know we've come up with these with various drive-through restaurants before, and if we had some type of something written in, that would be nice. Helpful.
Cindy, were you trying to weigh in as well?
Well, I totally agree with what you were saying, Nathan. And I just think that the drive-through signs, it makes sense to me that we approve what they're proposing. My recall is that that's what we approved for Southwest 9th. And as far as being able to see those signs off of Merle Hay Road, they're tucked behind. I go to this McDonald's and a couple of them are tucked behind. And I don't think forcing them to have a monument sign for a drive-through really makes that much sense. They're top quality signs. They look good. They work. The one sign that says, don't drive a truck or a vehicle in here that's more than 9 feet. That one's needed. Maybe they could take the verbiage off that. Maybe we could request they take the verbiage off that. But I think it's important that, people don't always pay attention to those either. So I am okay with the idea of the menu signs as they're proposing now.
Yeah, there are a lot of funny YouTube videos when people are not paying attention to some of those signs.
Right.
All right, other comments from folks on the board? Well, Cindy, do you want to make a motion?
Oh gosh, sure. I'd move. Gosh, I got to think about this one, Nathan. Am I going to move staff recommendation, but allow them their desires for the drive-through signs?
If I might, could I just suggest, and this is Judy Parks Cruz, don't try and take this as all one comprehensive fix-all. Parse them out and do separate motions. So those pieces that they're in agreement with and you believe that you'll have the votes for, take those as separate motions. Is that helpful?
Yeah, so I guess the first motion would be to move staff for the wall-mounted signs.
All right, that's a good starting point. So Cindy has moved that we deny the variance request for 4 wall-mounted signs, but go with staff recommendation, which would allow for an exception of 1 over the maximum 2, which would total 3 wall-mounted signs earned for the frontage along Merle Hay Road. Is there a second?
I will second that.
All right. There's a motion and a second. Any further discussion? All those in favor, say
All right.
aye during the roll call.
Cindy Smith,
Aye.
Marlis Jones,
Aye.
Justin Gross,
Aye.
Dave Gare.
Dave had to leave.
Okay. Lynn Carlson.
Aye.
And Nathan Blake.
Aye.
The motion carries 5-0.
All right. Well done, Cindy. Do you want to give it another go for the second item?
I guess the second item would be to move staff for the exception of the one signs for the drive-through for, let's see, use over the maximum 2 signs for the drive-through and take out the requirement for a masonry base.
All right. So you're, but you don't want to allow them to have all 4 signs. You just want to have them 3 of those drive-through signs.
Yes, because that would meet the exception.
It would.
Except that would take away the sign, God, help me out here. That would take away the sign that would try to keep people from driving too large of a vehicle through.
Yes.
Okay,
So-
I want to allow for that. So
Well, maybe just try it and we'll see what we get with what you want.
Can we have a little more discussion on that real quick?
Sure.
Sure.
I mean, I'm just thinking out loud here with, if you took out the drive-through and just the verbiage, even the clearance language, I mean, having the bar there, doesn't that itself sort of prevent and help with safety?
It just seemed like there was a danger that staff was still going to determine that to be a sign, possibly even with no wording at all. But even if you had just said clearance 9 feet, it seemed like there was a possibility. And I personally am not, I don't agree with that determination, but also I'm just not comfortable with kind of going through that path. I'm just not satisfied that if we didn't allow the drive-through, verbiage on there, that that would be a solution.
And I think we need the information on there. Not everybody is open to the obvious. And when it comes to safety, I mean, like, why do we have stop signs? Everybody knows by the red octagon shape, it's a stop sign, but we have it there because it's another thing for people to focus on and remember for safety. So I think we need to have the words on there.
Justin, did you read it differently or read their comments differently?
No, I struggle with, the fact that if we could take off the word drive-through, it's clear, it seems clearly that it's more of a public safety measure. And I just can't, I don't know. I wish we could kind of get around that somehow, because I don't think it's a sign. I don't think it should be by definition a sign if it just says clearance 9 feet. But I don't have probably the legislative support there for that.
Well, we're not really legislating. I mean, if this is the case where it works for free, we can definitely say that this is a safety fine or a safety, an informational safety thing. And that for signs, should we allow it, shall say drive-through clearance 9 feet and not anything else. Can't we?
I mean, we can say that in our discussion. I don't know that, because my understanding is because it was not noticed as a kind of like appealing a determination by the zoning enforcement officer, we actually aren't able to make a decision today on whether that's a sign or not. Our options are either to grant a variance, grant an exception, or deny both of them. The practical effect of granting the variance request would kind of mean it doesn't really matter whether they're determined to be a sign or not, right? They can do what they've requested. And it would not require, the implication would be that we wouldn't have to renotice this. They wouldn't have to stop their construction. We wouldn't have to come back in a month to essentially determine the same thing.
And it would be instructive to those of us as staff listening to ask more questions next time prior to the meeting, but we're learning that as we go through this.
So other comments on this?
And again, I'm just for discussion purposes. Is her name Miranda?
Yeah.
I mean, would this issue slow down anything if this particular issue was tabled and renoticed and then come back before the board next month? Would that seriously impede the development of this property?
I would have to say yes, because currently their drive-through is open and they currently do have a drive-through clearance bar, but I know that during the changeover, when they put in the new footings for all the other drive-through signs, they'll be putting in the footing for the clearance bar, which will be removing the old clearance bar, and they only plan on having the drive-through closed for a very short time for that. So once they have those footings in, they would open that drive-through up again and they'd be driving without a clearance bar at that point, which would cause that safety issue. Because of the location of where it's going to be, they can't leave it in, the old one in, and have the new footing in at the same time, if that makes sense. Okay. Because it's basically going in right where the other one is.
Thank you for that feedback.
All right. Anybody ready with a motion for this? I don't mean to cut off discussion prematurely, but if there is anybody that feels like they have the solution here, feel free to propose a motion. And if not, I'll come up with something. I shouldn't have said that last part. So my solution to this is to I'll move that we allow the variance requests with respect to the drive-through signs. Is there a second?
I will second that. Lynn Carlson.
Thanks, Lynn. Any further discussion? All right, let's see how it goes. Tyler.
All right, Marlis Jones.
Aye.
Justin Gross.
No.
Lynn Carlson.
Aye.
Cindy Smith.
Aye.
And Nathan Blake.
Aye.
The motion carries 4-1.
And just a point of clarification. So by granting that third variance, so you're allowing them to not have the masonry base beneath the signs? Correct. Which I'm fine with that. I just want to make sure that was your intent.
Yep, it was the intent for all of those. Yep.
Perfect. Thank you.
All right. That's it for item number 5. We move to item number 6, which is, surprise, surprise, a sign variance, zoning variance request at 111 East Grand.
Sure. All right. Thank you, Vice Chair, members of the board. Again, Bert Drost, planner for the city of Des Moines. The proposed sign would require 2 variances. This item is proposing a sign on the 4th floor of a building downtown for a 4th floor tenant. Our sign code only allows tenants within the 1st, 2nd, or 3rd floors of a building to earn signage. So since this tenant that would have the sign is within the 4th floor of the building, they earn 0 wall-mounted signage. So they're proposing 2 signs, one on the north facade, one on the west facade. Each sign would be 26.67 square feet. And since they earn 0 signage, they need a variance of 2 signs over the allowed 0, and then a variance of a total of 53.34 square feet over the allowed 0 square feet of signage. So the subject property is the recently constructed building at 111 Grand Avenue. It's just on the block to the east of City Hall. It's a 4-story building that backs up to a parking garage. So here's a sign that they're proposing for the 4th floor. And this is how it would appear on the building. So you can see here this Frederickson sign represents a tenant within the 3rd floor of the building, and the sign is on the 3rd floor. Then the proposed sign up here would be on the 4th floor, and it would again represent a 4th floor tenant. And this is a view of, so that last one here, this is the west facade of the building. And then this is the north facade of the building. So they would put matching signs at the corner. And this just shows the dimensions. It would be 20 inches tall by 192 inches wide. And here's a photo that gives you a better idea. Again, this Frederickson sign represents a 3rd floor tenant, and the proposed sign would represent a 4th floor tenant. This is another view looking to the south. Then the applicant supplied these signs that show, or these photos that show signs on the 4th floor or higher of buildings, just showing that the proposed sign would not be out of character with the neighborhood. But I have to point out that these signs, while they are above the 3rd or 4th floor of a building, they do represent an occupant of the entire building. So the signs are still on their occupant wall. And as far as the staff rate goes, as you know, in order to grant a variance, they have to demonstrate the unnecessary hardship and prove that the land in question cannot yield a reasonable return without these variances. So staff has recommended denial. And we did not receive any comment cards back. Any questions for me?
Questions for
Bert,
Bert? Oh, go ahead.
Bert, this is Cindy. I'm trying to wrap my head around the justification for allowing a sign for a 3rd floor business, but not a 4th floor business.
Sure. Well, if you remember our retired code, we only allowed 1st and 2nd floor tenants to have signage. So with the new zoning ordinance, we've recognized, especially downtown, it's fairly common for upper level tenants to want signage. So we did up it from the 2nd floor to the 3rd floor. But I guess the reason for limiting it as 3rd is we don't want to create a situation where there's a sign on every floor of like a high-rise building downtown. And again, where it's a 4th floor or 4-story building, it's probably not as critical as if it were like an 8 or a 20-story building. But the rationale for limiting it to the 1st through 3rd floors is just to, put a limit on what level of signage we will get downtown.
I imagine there's also a practical aspect to that. How much can you see from walking on the ground floor?
Yeah.
Going up? How much can you read?
Yeah, that's true. The higher you go, the less bang you get for your buck at the base level. When you're further away, you may be able to see the higher signs better, but.
Bert, the city just considered these regulations recently, right?
Yeah, these took effect December of 2019.
And that was a change from previous sign regulations.
Yeah. The previous ones, only the 1st and 2nd floor tenants earn signage, but the new code, and here I'll zoom in on the table that shows the earnings. Of course, I can't see the. So for wall signage, in the DX2 district, they earn 1.2 square feet per lineal foot of building frontage for floors 1 through 3. And each occupant earns a maximum 2, but again, they only earn those for floors 1 through 3.
Right, this is Lynn Carlson. I have a question again. If this tenant was on the second floor, would the size sign that they're proposing be fitting within the guidelines or not? It looks bigger than the one from Frederickson.
Let me do the math. So I think it's comparable, but so if they're proposing a total of 53 square feet of signage, and they earn 1.25 square feet per lineal foot of frontage, that means they would need 42.4 feet of frontage, which I don't think that would be hard to achieve or hard to have, 42.4 feet. So to answer your question, yeah, these sizes of signs would likely be allowed on the first, second, or third floors of the building.
Thank you.
Other questions for Bert? All right, then let's move on to the next stage, which is hearing from the applicant or representative of the applicant. Looks like a hand is up.
See Miranda again?
Yeah. Hi, this is Miranda Cassins with Chestnut Signs, 971 Northeast Broadway, Des Moines, Iowa, 50313. I can speak a little bit to the size of the signs. They do have 64 feet of tenant frontage along the grand there. So they would actually be allowed up to 80 square foot of tenant frontage. So the signs are actually smaller than they would be allowed. So we were trying to keep within the look of the building and the area and not go overwhelming with the signage. But again, so what's proposed is consistent with what's in the area. They went with a very clean look so that it wouldn't stand out in the neighborhood. It would go with kind of that East Village feel that's going on. I have been
Miranda,
told,
I'm
yeah.
sorry to interrupt. This is Nathan Blake, and I just wanted to, you've sat and been very patient throughout this process. Obviously, you're well versed in the signage department and have been good to work with on the last item. I did want to note for the record, there are only 5 members of the board present, okay, and it requires an affirmative vote of 4 to pass anything. When there are only 5 members, we, and maybe someone on staff can describe this a little bit better, but there's an allowance for the applicant to wait until next month. And I think you've probably read the tea leaves about how different folks in this board often approach sign variance requests, given that you've sat through now a couple hours of our deliberations.
Yeah.
But I wanted to just present that to you as an option if you'd like. And I don't know if staff has any other color to add on that.
I would just mention that if they would request the continuance, it would still take a vote of at least 4 affirmative, or I guess take a vote of the board to grant the continuance, but I can't imagine it wouldn't pass if the applicant.
Right, and this is Judy Parks Cruz, legal counsel. We started out with 1 fewer member than we normally have, and then we lost the subsequent one. So it puts a lot of pressure on those who are left to understand, to get a final vote for you, they have to count their own heads as to how many are left. We hate to put applicants in that position of having to wait, but we want to give you that opportunity as well.
I would request, Allison, are you here with Senator Cooner or Tim? the landlord, are you present at this meeting? Can you speak to how you would like to handle that?
Yeah, it looks
Yes.
like, yeah, go ahead.
Great. Tim Ritma, part of 111 East Grand. Would it be possible to kind of have a conversation with the board and see if we can kind of, if there's direction before making that decision? I mean, I guess we kind of thought it was a simple sign request that just fell in between the cracks. There's several buildings around the property that have signage higher than 3 levels. AC Hotel is another one that we didn't show photographs of. It's a new law firm starting up. We built the building. We've always intended for signage to be there. I think we've shown it in some of our early renderings when we were building this building 2-3 years ago. Obviously we want to be successful. We think the sign fits into the neighborhood, but we also we think it's, as a group, the best approach to come back in a month. I guess we're not against it.
So,
Mr. Ritma, if I might speak to that just a bit, the standards that are applicable to the request that has been made, which is for a variance, are established under code and under case law. So knowing those and having heard some of the conversations that we've had, it will be difficult to, I don't know how to say this tactfully, but it's more likely, if there are more people to vote, that you will have evidence that is viewed differently by additional members, such that you have a better likelihood of getting the 4 votes you need.
Got it.
The other thing I'd add, and I hesitate to go too far into speculating about people's positions, although if you've been sitting here for the last couple hours, you've probably heard them, and there are a few of us who are pretty skeptical about sign variance requests in general, given the legal standard. But if you were to take the position that you can just kind of want to hear it out, I think it's a much less likely that we would grant the continuation. I don't think people want to sit and hear the presentation and then vote for a continuation based on your kind of assessment of where our board might be. I think you just need to make the call whether to ask for that continuance now, kind of prior to presentation, or wait.
Would we be first on the agenda next month so we wouldn't have to sit for 3.5 hours of our day?
Yes, you would be the first discussion item on the agenda.
Okay, well, unless there's another thought between Zener Keener Law Firm, I think that probably is the direction I would recommend we go then.
All right. So what I've heard is that there's unless it looks like Allison might be the person represent, or Adam. There you go. Any further comment there? You have your hand up, Adam. Tyler, do you want to allow him to, or I can?
Thank you, Mr. Blake. And I listened carefully this afternoon and heard Mr. Ritma's comments. Agree with those and appreciate the council here. Why don't we continue this another month and we'll be back before you at that time. Thanks for your consideration. All
right. Appreciate you all being here today. And your patience with us again, and we'll hear that as a request for a continuation. Is there a member of the board that wishes to move, or do we just vote? I guess we don't need to make a motion.
Well, you should probably still have a motion in a second.
All right. Any member of the board who wishes to move to continue this until next month?
I move to continue this item next month. This is Marlis.
All right. Thank you, Marlis. A second?
I'll second.
All right. Any discussion? The only item of discussion I'd have is that I would anticipate that Mel's going to be back in charge next month. So I'm in favor of whatever I can push off. The burden of speaking is much higher on the chair than the normal participant. When I'm usually sitting back popping bonbons for most of the discussions. All right, Tyler, you want to call us through?
Sure thing. Cindy Smith,
Aye.
Marlis Jones,
Aye.
Justin Gross,
Aye.
Dave Gare.
Gone.
Oh, sorry. Yep, he's gone. Flynn Carlson
Aye.
and Nathan Blake.
Aye.
So motion to continue to June's meeting passes 5-0.
All right. Thanks very much. That will be continued. And now I think the only other thing we've got left to do is to approve minutes from last month's meeting. Is there anybody here who wishes to move approval of those minutes?
I'll move.
All right. Motion by Cindy. Second.
Second.
Second by Justin. All those in favor?
All right, Nathan Blake,
Aye.
Lynn Carlson,
Aye.
Justin Gross,
Aye.
Marlis Jones,
Aye.
and Cindy Smith.
Aye.
Motion carries 5-0.
Great.
Right.
Unanimous again. Bert or anybody else, anything else for the good of the order today?
Yeah, I just had a couple quick things I wanted to mention. I know before I had told everybody that we were going to be returning to in-person in July, but as of 2:09 this afternoon, I got an email confirming that we're actually having to push that back a month to August. They're getting some new sound equipment that's going to be installed in the boardroom at the Municipal Service Center in July. So that means we'll be doing our July meeting on Zoom still, and then we'll be resuming to in-person on for the August 25 meeting.
Okay.
And so then the other thing I was going to mention is that this is Eric Lundy's last meeting serving in his current capacity as a senior city planner. I believe you probably saw the email that he was recently given the opportunity to take the zoning enforcement officer role. So he'll be taking over that effective June 1st. So over the next few months, Sue Ann will be transitioning away from this board, and then Eric will be transitioning in to take over her role. So Sue, or I guess it was last year already, was chosen to be the deputy director of the neighborhood services department. So she's not leaving the city, but she is passing the baton on zoning enforcement.
Well, congratulations to both of you, and look forward to continuing to work with you, Eric.
Thank you.
I do note, it looks like Miranda still has her hand up. I'm not sure. I can't imagine okay,
there we go.
She doesn't.
Yeah.
All right. Anything further for this afternoon?
I didn't have anything else unless anybody else did.
All right. Well, thank you everybody for their indulgence as I stumbled my way through this process. Pretty successful in that we all lived, which is good.
Yes, you did great.
Good job, Nathan.
Yes, thank you, Nathan.
Yes.
All right.
And
And we'll be
Lynn
back with
will-
our fearless leader next month. we
Yes.
hope.
Yeah.
Yeah, and again, Lynn, we told you this last month, but we'll say it again. We wish you the best as you move to Minnesota in the coming weeks.
Yeah.
Hey, you guys, gonna miss this, really.
Yep. Thanks, Lynn.
Thank
luck.
you. Bye-bye.
See y'all.
Thanks, everyone.
This meeting
Bye,
is adjourned.
guys.